say, for example, that work was done in administration, so prior to 561 becoming an issue, because it doesn't come into play until you're in LIC, but you do that work then, at least you've got your statutory lien, right? You can take out of both, circulating or non-circulating, and then whatever happens in liquidation, it doesn't matter. But then once you're in LIC, or if you're in receivership, for example, it's a different kettle of fish.
Maybe you adjudicate the employees in administration.
Cathro and Partners presents The Cut, a podcast about all things insolvency.
Hello everyone, my name's Simon Cathro. I'm the Managing Principal of Cathro and Partners. Today is the next episode of The Cut, where this season we're primarily focusing on insolvency lawyers and special topics that we're experiencing in the insolvency and restructuring field. And it's my pleasure to introduce Emily Barrett from Johnson Winter Slattery. How are you, Emily?
I'm good, thanks, Simon. Thanks for having me.
And I thought before we get into the topics of discussion, we might just give you the opportunity to just give yourself a bit of an outline of yourself and the firm. So tell us a bit more about yourself and JWS, as we call it.
Yep, I'm from Johnson Winter Slattery, which is a national firm. I'm a partner in the restructuring insolvency team, and we've got partners all across Australia in Brisbane, Adelaide, Melbourne, you name it, and a new Canberra office as well.
Yes, that's right. Your corporate lawyer who does our work lives there too.
Yeah.
So I assume you're pretty busy at the moment with insolvency.
Yes.
It's an interesting time in insolvency. We're seeing a lot of work come in, and it's a little bit different to the GFC. We're seeing almost a different, with the GFC, sort of was the big end of town that started first.
Yeah,
and now it's sort of the opposite. It's the small businesses we're seeing the frequency of failures really pick up. But you've been working on some good sized matters as well, some construction companies. But today you've got a couple of topics you want to talk about, which I'm going to listen very intently and try and ask some questions. So do you want to just give us a bit of a summary of the topics you want to cover off today?
Yeah, sure. So Johnson Winter Slattery and the restructuring team put together this publication, our case summaries publication. It's into its third year now.
There it is.
And this is your copy after we're done, Simon.
Yes, I've got one, but it's a fantastic book, actually.
And basically what we do is we've got a team of lawyers and Sam Johnson, one of the partners in the Sydney office, sort of manages them. It's a big feat to prepare all the case summaries from throughout the year that we think are notable or worthy of our clients and other lawyers being aware about. And then he wrangles partners in the team to try and settle them. And then we put it together into this lovely publication and send it around to all our clients and share it around.
It's a lot of work.
It is. It's a lot of work. And it looks pretty good this year, I must say. Sam's done a really good job. So there's a couple of cases in here that I can talk to. The notable ones from the High Court decisions last year. The Morton case on Section 553C set off, and then Bryant and Badenoch, and then a couple of other ones, lesser known ones that you and I have worked on together as well. And then finally I'll probably run you through a decision I did on IOU pay last year.
Great. Well, which one do you want to start with? The 5.3, what was it? What section was it?
Yeah, 553C. So we'll start with that one.
I should know these sections, but anyway.
They're all marked in here for you.
So what was the name of this case?
So this is Metal Manufacturers and Morton as liquidator of Woodman Electrical Contractors.
Yep. And what happened in that?
So basically this was a High Court hearing where they were looking at whether or not you could use Section 553C, which is a set-off provision, in defence of an unfair preference claim. So 553C is basically available where there's mutual debts, mutual credits, or mutual dealings that a creditor can then set off the position and put their net proof of debt into the company in liquidation. Basically, the court said you can't use it for an unfair preference claim, and it's because of the timing of the mutual dealings. They have to be prior to the appointment, and an unfair preference claim is a liquidator's action that arises afterwards, appointment. So, it's just kind of neatly dealt with that point, the High Court did, and basically you can take it and run with it now for voidable transaction claims that it's a given that you can't rely on 553C.
Okay, so thinking about that decision, what were the key facts of the case that we should just explore a bit further and give us a bit more of an outline on that?
So basically it was a liquidator's action to recover an unfair preference payment. So unfair preference payments are amounts that are paid to creditors prior to a liquidator being appointed in the relation back period. And a liquidator is able to...
Which is 6 months, isn't it?
Yes.
Correct, yeah.
And a liquidator is able to claw those back basically so that he can distribute pari passu to all the unsecured creditors that prove in the liquidation. So it's basically about treating all the creditors as equitably as possible.
Yep.
Section 553C has a different operation. It's basically there so that a creditor who is owed money by the company and who also may owe money to the company can set off those two positions and then just prove the net as an admissible proof of debt in the liquidation of the company. So they are looking at different times, probably is the simplest way to describe it.
Yep.
553C is looking at those mutual dealings being prior to liquidation, so the existence of the debt owed by the creditor to the company or the company to the creditor need to arise before the appointment of a liquidator.
Yeah.
An unfair preference claim that whilst there are circumstances in relation to payments that are made prior to the appointment of a liquidator, the key factor here is that it's an unfair preference claim isn't actually available.
Yeah.
And isn't something that a claim that can be made until after liquidation, so it doesn't arise at the right time.
Yeah, it's an interesting one because I suppose the defendant, the party that was trying to argue the mutual dealings, would have been saying, well, there was something that happened prior to the appointment. That's the actual preference payment in itself.
Yes.
So that's our argument to say that it did actually happen because, of course, the voidable transaction being the unfair preference payment doesn't exist prior to the appointment because it can only be created or the opportunity created by the liquidator being appointed.
That's exactly right.
And so then the court said basically, no, it is actually a new event, I suppose, if you want to call it. It's not a continuation of an event being the time that the actual payment was made.
That's right. I mean, if you think about it, I put my lawyer's hat on. It's not a cause of action that existed at the time that the payment was made.
Yeah.
So there was no way to recover it.
The cause of action is the event. And then the court then, I assumed, then determined when does the event commence.
Exactly.
And the commencement of that was at the time the right to sue for an unfair preference is the start of that event.
Exactly. That's exactly right.
Yeah. Interesting. Yeah. Okay. And so went to the High Court. Was there any... Do you know the background around? Was it overturned? Was it just went through the various courts? Do you know what happened in terms of the decisions throughout that process?
Yeah, I believe it was actually just upheld the Court of Appeals decision.
The summary from that then is, if a liquidator has an unfair preference, they have no risk or little risk. We should never say no because you never know. Of a defendant running that argument that
exactly,
we want to offset this against monies that we're owed.
Yeah.
Was there any link to some of the ATO preference settlements? I know with some of the claims that I've been involved with the ATO, they've run a number of arguments, and so when we get to, and we more often than not, settle with the ATO in some of the larger claims, either via letter or through a mediation process. But sometimes they'll run claims around mutual set-off. Did it clarify that law, or was that a different sort of decision?
I'm not sure exactly what you're referring to. It could be you could be talking about equitable set-off. Is that
potentially? Yeah.
Yeah. No, it just dealt with 553C.
Just the 553C. Okay. All right, so what's your next topic?
Well, the next High Court decision was the Brighton Badenoch, which everybody's talked about. JWS was actually involved in it, not me. I wasn't. It was our Melbourne team, Paul Booten-Dargan, Praveen Arthreya and Ben Renfrey from Adelaide that basically ran that. Went all the way to the High Court, and basically the High Court was, again, looking at unfair preferences, but this time whether or not a liquidator has the ability to pick the peak indebtedness to try and maximise the amount of the unfair preference claim.
Yep.
And this is something that had sort of, I think, a rule that had come up in case law over time. I think it actually originated from New Zealand, and basically allowed a liquidator to try and improve the amount of the preference claim that it might otherwise be able to recover in the prescribed period, which is, the 6 months.
So peak indebtedness, tell me about that.
Yeah, peak indebtedness, basically what the words imply. It's that, during the prescribed period, when is the indebtedness of the creditor at its highest?
Yeah. Yeah, so let's say you have $1 million at the 1st of July, liquidator gets appointed on the 1st of January, so you've got that 6-month period.
Mm-hmm.
At that, the debt's $1 million on the 1st of July, but say get to the 1st of October, it's $1.5 million, and then come 1st of January, it's $500,000, right? When you look at that example, so the peak indebtedness would have sat at 1.5, and then what happens from there?
Then you can look at the net position basically as like...
From that 1.5 onwards.
Exactly.
Not from the 1 million, it's from the 1.5.
That's right.
Yeah, so it's not the 6 months, which we always so commonly hear about. It's actually, in that example, it's 3 months.
Yeah, a truncated period of time based on when the peak indebtedness is.
So arguably in that simple example, you'd say the preference payments was $1 million when it went from 1.5 down to 500.
That's right.
And but then you've got a lot of other sort of defences like running account defence and other defence.
Yeah, that's right. And I think basically the High Court just said, well, this peak indebtedness rule is not codified in the Corporations Act in Section 588FA.
Yep.
And it's very clear that the period that you're meant to look at is a prescribed period. So the only time where you truncate the prescribed period is if the date of insolvency is somewhere within that period of time,
Yeah, of course. And then, of course, there are a number of things that we have available to insolvency now where there was a reasonable expectation that the business would come out of it. So in that sense, so what it's saying then is that the 6 months stays, and we don't have this situation where potentially it drops down to 3 months in that example. Because if it was at $1 million, say on the 1st of July, but it went up to 1.5 in the 1st of October, there still could have been $500,000 of other payments that were made, and there was $1 million of transactions that happened in that period. So interesting. Okay.
Yeah,
and so your firm was on that, and that went to the High Court.
Yes.
Do you know why it went into the High Court? So what was it? Was there any through the process, or was it just the court confirming what the earlier courts had said?
No, it was as appeal from the Court of Appeal's decision, because really the Court of Appeal's decision, and I may get this wrong because it's not my case, but the Court of Appeal's decision left a little bit of uncertainty about how this rule still operated. So it was a decision to bring it, even though prospects may have been a bit iffy, to essentially resolve the position, make it very, very clear for liquidators whether or not this rule was available to them.
So what's the next one?
Oh, the next one. Well, there were a couple of other important decisions last year. Commonwealth and Tonks, I think everyone's familiar with, where FEG, who had paid for employee entitlements and was able to subrogate to their position under Section 560, basically appealed a judgment which was an application brought by a liquidator for a direction that he was entitled to sort of pay his remuneration under 556.
Yes.
Basically, the 561 wasn't in play.
Yes.
It's a judgment that's been wielded around a bit, and there's some complexities to it, so I can break it down for you. Let's break it down,
because I am across this. In fact, I had a presentation a couple of weeks ago from the barrister that acted on that. So, it was. It's been one that's been, let's call it a very problematic issue for the insolvency industry. On the one hand, FEG, who's been a great supporter of our industry, has also been our opposition in terms of the insolvency practitioners having a firm view that we should have priority over them. So why don't you just give us a brief summary of sort of what it is, because it is very complex, but it is fundamentally got to do with priorities and who gets paid first and who gets paid second.
That's right. So Section 561 of the Corporations Act basically comes into play where the free assets of the company are insufficient to pay priority creditors, so employees.
Yeah.
And in that situation, that section of the Act provides that priority employees can be paid before a secured creditor from circulating assets.
Yeah.
So in that instance, employee creditors would get paid out first, secured creditor gets paid out second, and generally speaking, like a remuneration of a liquidator or something like that would come out of it, universal distributors lien in realising those circulating assets.
Yeah.
So in the Commonwealth and Tonks decision, that was basically the question that they asked the court to determine was whether 561 was actually in play over circulating assets.
Yeah.
In that case, it's still...
Yeah. So for the layman people that might be watching, circulating asset is cash, debtors, inventory, and that's probably pretty much it, right?
That's it. Basically things to trade the business.
Your non-circulating assets is your motor vehicle, your plant and equipment, your property, real property.
That's right.
And that's in its simplest form. And then if you have things like bank guarantees, goodwill and all that stuff, some of these unique assets often need a bit more analysis as to what they classify as.
Yeah.
And the other thing too is it depends also on the type of business too, because if you've got a business that trades in property, so builds apartments and builds buildings and lots of buildings, and that could be a circulating asset because it's debtors or something like that. So you have to look at that very carefully. But on that basis, what we got there is we had, and then you've got the employee entitlements. So the employee entitlements, and let's call that there was 100 employees. They're owed $1 million, and they have a priority over the unsecured creditors. So the trade creditors or the tax office. But then it comes down to there's a bit of a mess, if you want to call it, when you start to having a secured creditor. You've got different types of assets, being the circulating asset and non-circulating asset, and then you've got thrown in there is our costs, our fees and remuneration. And so there had been, for a period of time, an argument run by the government, FEG, as to who should get paid first out of that. So this is what this case clarified for everyone.
That's right.
And good news that the liquidators won.
Yes, exactly. Yeah, so in this one, the court basically said, well, we're looking at 556, which is the regular priorities for distributions and liquidation.
Yep.
And under 556, liquidators get your rem and your costs first, employee creditors come out after.
Yep. And then unsecureds after that.
And unsecureds after that.
Yep.
And so the liquidator was trying to make the case essentially that he could take his rem and costs out first and then pay FEG, standing in the shoes of the employees. And FEG was saying, well, no, we think 561's in play here. And because 561's in play, you don't get your rem and costs first.
Yeah.
Employees first, secured creditor, and then the only thing that a liquidator might get would be a universal distributor.
Yeah, so it almost turned the priorities on its head when it becomes a bit messy, and it makes it very complicated. Really, adds a lot of complexity to what should not be a complex issue. I mean, I think honestly, you should just keep to one set of priorities and be done with them. Whatever those priorities are, make it clear. Don't make it sort of changeable based on other sections of the Act.
Well, that's right. And it is, when you think about taking an appointment as an administrator first, then leading into liquidation, you've got other questions that come in as well, like, when do you take your statutory lien out? When do you take your universal distributors lien out? And then how that plays into what happens once you're in liquidation too. Yeah. In Section 561.
Do you want to talk a bit about the universal distributors one, just as to what that case covered as well? Yeah,
so universal distributors lien basically was a case that said that you're able to take out in priority any fees and costs incurred in connection with realising or preserving a particular asset. So this is sort of distinguishable from what would be your ordinary expenses as a liquidator in complying with statutory duties once you're appointed or pursuing other actions unconnected to whatever asset that you're trying to realise. So it basically bumps you up ahead of a secured creditor if you've helped realise that asset.
Yeah, but for the part like creditors' meetings, report to creditors, your lodgements that you have to do with the various ASIC obviously and ATO, but to utility companies, that's not captured.
No, that's not captured. Yeah. So then you just have to wait for your 556 distribution and liquidation. Yeah,
and that's a great example of some of the significant risks that insolvency practitioners take on, is that they can often do a lot of work and not get paid for it.
Oh, 100%.
And so in that case, that was clear. It's been a very well thought of case and has clarified a lot of things for the industry in the sense that we now feel with comfort that we could get paid for the preservation of assets and be first.
That's right.
And it makes a lot of sense. I mean, if employees are going to get paid by the cash that you create from the realisation of the assets that are not cash, then it only makes sense that the people that created the conversion should be paid first.
Paid for the work that they did to realise that 100%.
So coming back to this FEG case then, when you look at that decision and the FEG case, what was the key reason was this implication of the Section 561, right? And so FEG would then turn around and say, hang on, no, that's our money. First, because 561 applies, and we're ignoring 556 and the universal distributors, and basically just went on this path of arguing that there's a different issue to what I thought was a fairly clear decision in universals. But thankfully, what the FEG case has done is really covered it and said, no, the liquidators do get paid.
Yeah,
first.
so the Commonwealth and Tonks matter basically looked at when 561's engaged, so when it applies.
Yes.
And the court decided that it only applies where the free assets of the company are insufficient to pay out employee creditors or priority creditors.
Yeah.
And when the company is in liquidation. So the point in time when you look at it is in liq, so not administration.
Yep.
And when the free assets are insufficient to pay employee entitlements. And then the third bit is when there's a secured creditor still in play over the circulating assets.
Yeah.
So in the Commonwealth and Tonks matter, Westpac was a secured creditor, but they'd already been paid out at this point.
Yes, that's right.
And so the court said because they've been paid out, there's no contest over the circulating asset pool. There's no secured creditors, so 561 doesn't operate. And so 556 is the priority regime that you look to in relation to any contest between a liquidator's rem and costs and paying employee creditors.
So Westpac got paid in full?
Yes.
All right. Then we've got a bunch of money, and then that was the money that was in dispute.
Yes.
Who goes first, the liquidator or FEG or the employees?
Yeah.
So let's say there is a secured creditor, and so Westpac is still in there, for example. What happens then? Is it the same or does it change? Then
561 would be in play so long as the free assets were insufficient to pay out the priority employee creditors.
Yeah. Okay. All right. So short answer is if Westpac, if the secured creditor is not there anymore and has been paid out, liquidator gets priority. But if the secured creditor, e.g. Westpac, doesn't get paid out, then the liquidator's fees are problematic.
That's right.
Yeah. Yes, and that's probably a law that we'd like to change as well. But
but I mean, to the extent that the liquidator's been involved in realising that pool, you're always going to have your universal distributors lien.
One of the things that I wonder too is the work you do on adjudicating the employee's claims. Now, that's not preserving the assets.
No, it's not.
But how do you know what to pay the employees if you don't do the adjudication?
Take that one to the court.
That needs to go to court because I can see very clearly with my insolvency practitioner's bias hat on that, well, if you can't get paid for doing that adjudication, and let's look at this, in the real sense, right? Mm-hmm. Employee last week, we're about to pay out some entitlements on a receivership, and we went through the records. Let's make up some numbers, but he says we calculated he's owed about 4 weeks worth of annual leave. Mm-hmm. He comes back and says, no, it's 5. Right? So we go back and forwards. We spend an hour on that particular employee trying to work out. And look, it didn't worry us what the number was. It's what's right. Okay. So, but we had to engage the former bookkeeper. We had to contact the former bookkeeper. We had to access the Xero accounts. We had to speak to the employee. We had to look at the bank statements. Just on that one employee to work out what he was owed, right? Now, on that basis, if the secured creditor's there, right, it would seem that I've just spent an hour and times that by 100, 200, some of the jobs you and I've worked on, we've had 200 or 300 employees, right? Yep. I've just done all that work and I'm not going to get paid for it. Now, Section 545 of the Corporations Act says if you're not funded,
you don't have to do the
don't
work.
have to do the work. So what do? I just I think there is a solution. Like what FEG does is they then go and hire someone to do it, but that process is limited to a sort of a very set fee, often small, and you don't get the full recovery. So that to me doesn't seem right. I mean, if firstly you want to make sure that those employees are getting paid the right amount, and they are pari passu with another employee. So if this employee is 5,000 and we tell employee A they're 5,000, and employee A goes, yeah, that's fine. And employee B we'd say is 5,000. No, I made 10, and you don't do the work, and he or she only gets 5, and that's wrong. Then that's not the right outcome. If you've got $10,000 to split between the two of them, so to me, I think that part of that needed to be clarified. And it's a bit of a shame that Tonks didn't actually cover off on the broader impact of that
the
process.
work that's involved. It's interesting because it really does depend on your appointment type too. But for example, that work was done in administration, so prior to 561 becoming an issue, because it doesn't come into play until you're in LIC. But you do that work then, at least you've got your statutory lien, right? You can take out of both, circulating or non-circulating, and then whatever happens in liquidation, it doesn't matter. But then once you're in LIC, or if you're in receivership, for example, it's a different kettle of fish.
Maybe you adjudicate the employees in administration.
Yeah.
So the lesson there is practitioners should really quickly work out what it looks like if it's heading down the path of liquidation.
That's right.
But, obviously if you go into administration, your goal is to keep the business alive. So usually you go straight into liquidation rather than do VA to liquidation.
That's right.
There's only certain unique situations that would make sense for doing both processes. That was an interesting one. Lots of sections. Those that are not au fait with the Corporations Act and our wonderful jargon that insolvency has. But I think the point being on all those cases is that it seems like there's a debate over the interpretation of how the sections of the Act work. And it's a very complex, whilst you and I might live in that world and breathe it and think that it's it's normal language, it's actually for the layman person it's very complicated and confusing. But the fundamental takeaway there on its most simplest level is that we are trying to adopt a fair payment process of monies that we convert into cash. We convert assets into cash. That's our job. And trying to say, right, where should that cash go first? And employees have always been paid first before unsecureds. And then secured creditors come in and muddy the whole thing, but they also take certain steps to secure their assets, and that's what gets done at the time they lend the money.
Right.
So it does become very, very, very complex, and certainly for those that are involved in this process, it's important that you speak to a specialist insolvency lawyer. And I say specialist insolvency lawyer because I've had the luxury of dealing with lawyers that don't actually have the experience, and it becomes a tutorial on trying to teach the person how to advise.
Yeah. I mean, it is extremely complex, a lot of the provisions in the Corporations Act, and then just generally needing to have an understanding of, what's circulating, what's non-circulating. It's hard, so you need someone who knows what they're doing.
Good. Okay. What's your next topic?
Talking about complexities in the legislation, the next one's even worse. 561's hard, but this is even worse. So this is a case, 588FL, you and I did in relation to Cubic Construction Company. 588FL is a peculiar section of the Corporations Act, but in terms of the language that's used and trying to understand how it operates. But at its heart, basically, it's a provision, it's a voidable transaction provision that allows a liquidator to void last-minute security interest granted to creditors in the 6 months prior to appointment. So basically, any sneaky deals trying to give somebody a bump up the ladder as a secured creditor can be.
Like a preference pay, but a bit different. Right?
Exactly.
And void being we want to overturn what happened.
Yes.
Because it's unfair on others.
Exactly.
Yeah.
And so what it does is basically on appointment, those security interests, if they've been registered within that 6 month period of time, or they haven't been registered in the 21 days that they have to be registered in, they vest in the company, which means that the secured creditor loses their security interest and the company gets the benefit of whatever the asset is.
Yeah. And so what was the decision then? What happened? So
So our cubic matter, we basically had a situation where you were appointed as liquidator.
Yep.
And you did a deal basically to pay out the National Australia Bank and input another secured creditor. And as a process of doing that, that secured creditor wanted to take a security interest.
Yep.
And because of the wording in Section 588 FL, there was a question about whether or not that transaction, the security granted whilst we're in liquidation, was captured and then vested, and the new secured creditor coming in, which was Egerton, would lose its security interest. So we basically ran off to court and said, look, we don't think we need your help, Justice Cheeseman, here, because we don't think this section of the Act captures security interest granted during a liquidation. But in case we're wrong,
please advise.
Please help us out here and give us a declaration that we don't need to seek relief, basically. That section of the Act was the subject of a number of different cases beforehand. Yeah. A lot of judgments in the federal court that basically said that post-appointment security interests are captured. And then one standalone judgment of Justice Barrett in the Supreme Court of New South Wales said the exact opposite. Yeah. So it was completely unresolved.
Yeah. And so what does this do for practitioners then? It creates a commercial opportunity, doesn't it, in some ways?
Basically. I mean, so Justice Cheeseman ended up agreeing with us that we didn't need to seek relief, and her judgment's not the only judgment that has done this since. Justice Jackman's done one in Rev Ref, and then there was another matter, Flemington Racecourse, I think, as well, where the judge agreed essentially with the Supreme Court that if you're a liquidator who's offered a security interest or another type of appointee, you don't need to worry about 588 FL. It doesn't apply to you. And so basically what it means is for you, Simon, you don't necessarily have to run off to court to get some sort of corrective relief under 588 FM to stop the vesting of that security interest.
Yeah. It's very complex.
It is very
complex. I'm trying to work out how to say that in layman's terms. But in essence, it's, if you take that example, it was one secured creditor getting replaced with another one.
Yes.
To resolve to pretty much stop the continuation of the receivership, which was to the detriment of creditors.
That's right.
And by taking that action, that was a better outcome for creditors. Mm-hmm. And again, that's those kind of situations do come up where, and they're unique, right? And this is one of the wonderful things that we experience in our industry, is that we get presented with strange and different opportunities, and then we have to somehow work out what section of the Act applies, and certainly that was it.
Yeah, that's exactly right.
And you got one more. We've got time to do one. Is the UPay one?
One more. UPay. So this was one that I ran last year with Sam Johnson, another partner at JWS. Basically, we were acting for PwC, who had appointed administrators of a publicly listed company called UPay Limited.
Yep.
There was a whole lot of things going on with this company. So it's a public company listed on the ASX, but it had its trading suspended.
Yep.
Now, the trading had been suspended because of allegations of fraud. The allegations of fraud were at its subsidiary level, and all of its subs were in Malaysia. So this company, UPay Limited, was a holding company that didn't do anything, didn't trade, didn't have any employees, no leases, nothing. It was all at the sub level. That's where the value was. But some fraud happened at the sub level, and as a consequence of that, suspension of trading happened on the ASX. And then there was an EGM convened under the Corporations Act to replace the board of the holding company. And it was during that process of that meeting needing to be convened that the administrators got appointed.
By the people that were outgoing?
Yes,
by
the outgoing people. So the company at the time the administrators appointed was insolvent.
Yeah.
So that was, without a doubt.
That was not in dispute?
It was not in dispute. Yeah. It was insolvent. There was questions about whether or not the administrators had been appointed for an improper person by some of the shareholders. Sorry, not by an improper person, for an improper purpose. Because there was an EGM on foot and maybe there was some attempt to try and stymie it.
Yeah.
But as it happened, there was no ability to adjourn or deal with the EGM because of the way Section 249E, I think it is, of the Corporations Act operates. Basically, you have to, once a meeting, like a notice has been given for an EGM, you have to hold it and convene it, complete it within 2 months period. Yeah.
So that happens in the VA period?
That happened in the VA period. So we couldn't adjourn it. We're too close to the end and it's like statutory mandated. So what happened at
the EGM?
They rolled the whole board.
But it was in VA?
Yep.
And they had no powers. And for those that don't understand, when you're appointed administrator, your powers of directors are suspended.
That's right, but not the powers of shareholders to roll the board. There was a question about whether or not we could just put them back in again if we wanted to, because the administrator does have that power.
But you're an individual that's just consented to act as a director. Company goes into VA, you'd think logic would prevail and you would just withdraw that consent and say, I'm not going to put my hand up for being a director now. Now it's in administration, but they did.
Yep, but they did. And then what they did is they commenced an application under Section 447A of the Act to terminate the VA on the basis that the company was solvent.
And did they get up on that?
They did, but what they did was not on its present state of solvency as at the appointment of the VAs, but on the basis that they were going to tip funding into the company and the funding would make IOU pay whole.
Yeah.
It was very interesting because ultimately we didn't oppose it. We just waited until we were sure that this proposal was one that we thought had legs and could work and the company would have a chance of paying it back.
So there's a lot of certainty around the funding, which is not often always the case. Sometimes it's all a bit questionable where the funding's coming in.
Yeah, so this one was, the finance was going to be for 12 months. So like a long period of time, but not such a long period of time that you don't have to consider the future solvency of the company. So that was in question.
Okay. Yeah.
447A basically allows you to terminate if the company is presently solvent. But because it's a discretionary remedy, the court can consider things like the future solvency. Basically, they're not going to want to terminate a formal insolvency appointment like an administration if, in 2 weeks it's going to be back in VA again.
Yeah.
So the court had to look at the future solvency as well and consider whether or not, within 12 months' time there was an ability to pay it back. And ultimately...
But they gave 12 months.
It was a 12 months funding.
Quite long. Quite long, because I would have thought courts would be nervous about giving relief around it when it takes 12 months to make it whole.
So the money could be drawn down immediately.
Yeah, so the directors, so the VA is essentially annulled, really, and so as if it never went into VA.
That's right.
And so those directors are not affected, because just for those that don't know where I'm coming from, if you are a director of a company that's insolvent and it goes into some form of external administration, it is what we call the black mark against your name. If you have two companies unrelated that go into administration or liquidation, there is a risk that ASIC could take action to ban you as a director. And so, and of course, in addition to that, if you're consenting to act as a director on a company that's insolvent, you're almost immediately exposed to insolvent trading from the time you get appointed. So, very interesting. But those are some interesting topics. Lots there to talk about. Lots for everyone to take in. Very complex. It's a really good. Today's episode really covered off on some great examples of how complex some of these insolvency jobs can get. And you can see why there's a lot of involvement in the court and why there's a lot of sections of the Corporations Act, because there are situations that come up in jobs every time that is very different. And even your most basic of court liquidations can often be quite different to the next most basic of court liquidations, because everyone has its own little unique story. So,
right.
But thank you, Emily. It was a pleasure to have you on our show, and I hope you got a lot of enjoyment out of it. And look, for those that need some help in insolvency, do reach out to Emily. And of course, you've got that wonderful book there that's got some light reading for those that are into cases and that. I've had a look at it. It's a lot. It's a lot.
There is.
I think it took me about 15 minutes just to scroll through it. So, but thanks a lot, and thanks for for today's episode. And we will see you in our next podcast.
Thanks for tuning in to Cathro & Partners The Cut. We hope you've enjoyed today's episode. For more insights, please visit our website, cathropartners.com.au, or find us on LinkedIn.